Blackman, MP for Harrow East. I've had the privilege of serving on the Levelling Up Housing and Communities Select Committee, or its various different forms, since I was elected in 2010. I've also had the privilege of delivering 2 private members' bills during my time as a Member of Parliament. And so what I'm going to do is talk you through how private members' bills work and indeed how MPs go about choosing the subject that they want to put into law, and also the process and difficulties that anyone faces in trying to deliver a private members' bill. My first private members' bill was the Homelessness Reduction Act. That gave me obviously a great insight into how the process works, what the pitfalls are, and what you need to do in order to achieve the end result, which is to change the law for the benefit of the people in this country. The Homelessness Reduction Act was passed in 2017. It was the longest private members' bill in history, and also the most expensive for the government, in requiring £91 million to be paid out.
And of course, my experience on the Homelessness Reduction Act back in 2016 was a key pointer, because
the Jim Callaghan government in the 1970s passed legislation that meant that families had to be assisted by local authorities, but it took another 40 years before we got to the position of single individuals being assisted. When I went in for the ballot, I'd got an idea of what I wanted to do. I sit on the Levelling Up Housing and Communities Select Committee, and we'd done an inquiry into supported housing exempt accommodation, and we were shocked. I think all members of the committee were shocked by the dreadful treatment that vulnerable people were being given by rogue landlords.
The aim of this bill is to ensure that the vulnerable residents in supported housing are provided with proper support and care where they need it, and to drive out the bad providers.
In the run up to and the field work that I did before producing the bill, and before we start on the process, I went to Birmingham as one of the areas that I'd seen, and I saw properties that had been developed, and they are literally shoeboxes for people to live in. It's an existence rather than proper accommodation, and exorbitant rents being charged. And that to me is something that is scandalous in this day and age. Now essentially, the position with supported housing, which is a very broad concept, this is to provide people that have various different needs, and they need to be assisted to have somewhere to live, but also support in rebuilding their lives.
I've had the pleasure of meeting several direct witnesses of supported housing. Many of my colleagues in the Chamber today will have listened to Wayne and Ian, both from the Crisis Skylight in Birmingham.
Rogue landlords have literally, without assessing the individuals or their needs, or indeed their security requirements, have just lumped people into a property. That has to end. We've got to get to a position whereby supported housing is provided for vulnerable people, but people are protected. So people fleeing domestic violence, they're not put in the same position in the same house as a potential predator. Equally, recovering drug addicts are not put in the position whereby someone who has been imprisoned for drug offences is not in the same property. We've got to make sure that the properties are suitable.
The arrangements have attracted the very worst kinds of landlords. These businesses can be so lucrative that one MP in the Commons debate on the bill commented that the profits were higher than for dealing drugs.
Now, there are many providers across the country that do a brilliant job, absolutely brilliant job, in terms of providing supported housing. These are, many of them, charitable organisations.
Has been provided by the charity Crisis, which does so much good work in this field.
Baroness Walmsley brought up the impact of good on good providers, and I think this is a really important issue. There are some fantastic providers up there.
Was of course a voluntary scheme has been introduced, but of course the good providers register for the voluntary scheme and the bad providers don't.
However, sadly, there are a number of rogue landlords. One of the problems that exists is that in supported housing there are exemptions that apply. So because of the additional costs that come with supporting someone who's vulnerable, then these properties are exempt from the housing benefit regulations. So landlords can charge whatever rent they wish, and housing benefit will fund it. Now, as I've said, in the vast majority of cases, we're talking about charitable organisations that do a good job and justify exactly why they need to charge a bit more rent. But rogue landlords have discovered that you can literally buy a property, could be a 3-bedroom property, use all the permitted development rights, and suddenly your 3-bedroomed house becomes an 8-bedroomed house with a small kitchen, a small shared bathroom, and then the ability to house 8 vulnerable people. More importantly, charging an exorbitant rent. And these rogue landlords provide no support whatsoever to those vulnerable tenants. They literally will pack them in, and indeed they have the audacity to turn up once a week and say, "Is everyone okay? Fine, we'll see you next week." And that's the extent of their support. Worse still, if someone had the temerity to actually get a job or do something to improve their lives, they'll be kicked out of the home. Why? Because suddenly, because they've got a job, they will no longer be entitled to get the enhanced housing benefit. So the rogue landlord no longer gets the huge amount of housing benefit from the public purse. You know, we met some people who were being exploited, had been moved from one set of premises to another without their agreement. That had been told if they didn't behave themselves, then they'd be kicked out. When they weren't misbehaving, they were just asking for the accommodation to be made reasonable. Frankly, these sort of people are extremely vulnerable. They don't have a voice, and therefore it's important that we politicians can actually be their voice.
And I was left to cope. I couldn't cope, and I was then basically inserted into the exempt accommodation once I became homeless.
Supported housing exempt accommodation can only be provided by charitable organisations or not-for-profit organisations. Unfortunately, the rogue landlords have exploited this position.
Failing vulnerable people.
They buy the property for themselves and they own the property. Then they rent to a so-called not-for-profit organisation where they just happen to be the directors of the not-for-profit organisation as well. So they're gaining financially and they're not providing the support. Once again, this is another area which is covered by the legislation which we intend to root out. It's unfair on the tenants, it's unfair on the good providers, and it's unfair on the neighbours that have to put up with these rogue landlords. It requires a local authority to review the need and establish how much of a supported housing need there actually is, and then compare it to how much they've got already. This then allows a position of developing further supported housing because there are vulnerable people that require it. Under a registration process, all supported housing has to be registered with the local authority. The local authority have a requirement to maintain standards. They have a requirement to make sure that properties are suitable, that also support is being provided to the vulnerable tenants. There is a requirement on suppliers of supported housing that on entry, when someone is coming into supported housing, they are carried out a proper assessment on their needs and then a support package built around them. Up until now, that's not been a requirement, but good local providers already do this. For the 3 days after the King's speech, MPs who are backbenchers could literally write their name in a book against a number. So I was very fortunate that when I was drawn number 5, we had the idea of what we wanted to do, and so I, together myself and my parliamentary assistant, got together with the homelessness charity Crisis, with whom I've worked with a long time, and they commissioned a pro bono lawyer who wrote the details of the legislation that we wanted to put.
Bob Blackman.
Supported Housing Regulatory Oversight Bill.
Second reading what day?
Friday the 18th of November.
Friday the 18th of November. Thank you.
So, first thing, obviously consult with the department. Equally, we waited for the report from the Select Committee with its recommendations to make sure that we incorporated all of the recommendations within the bill. Having done that, we also then looked at having what we call pre-legislative scrutiny. In other words, the Select Committee looked at the bill, took evidence from various different people who gave evidence on whether we got everything right, whether we needed to make amendments. If your private member's bill, when the debate starts at 9:30, if you haven't had a vote on your private member's bill by 2:30 in the afternoon, your private member's bill falls. If you get someone who can speak for a long time, comes on a Friday and just carries on speaking and talks the bill out, that's the end of it. It's always important when you're pursuing a private member's bill first to make sure you've got support both from a cross-party basis and from the government. And equally, if there are members of what I would call the awkward squad, namely people that like to disrupt private members' bills, that you've spoken to them and made sure they understand what you're proposing to do, and ask them if they've had the opportunity, if they want to take the opportunity to look at the bill in detail and see whether there's any areas with which they disagree. That to me, for anyone pursuing a private member's bill, is absolutely vital, because otherwise you will get nowhere. A lot of the initial draft in the bill was removed because we agreed with the department that this should be put into secondary legislation, i.e. after the bill had become an act, we put this legislation in its place as regulation. The advantage of that is that regulations can be altered as matters change, whereas primary legislation has to go through a very long process, as I'm describing now, before it becomes law. So changing primary legislation is very difficult, changing secondary legislation much easier. So after we had the second reading, in which we had debates right across the House, got support from a cross-party basis, I'm pleased to say the second reading passed without the need for a vote.
Well, hope, Madam Deputy Speaker, that the House will indeed pass this bill and we can then get on to the committee stage to look at it in much more detail.
The question is that the bill be now read a second time. As many as that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it.
The bill then went to what we call the committee stage. Now, the committee stage is literally 17 MPs in a committee room, going through the bill literally clause by clause, line by line, if necessary, word by word.
The question is that Clause 12 stand part of the bill. As many as are of that opinion say aye. Contrary, no. I think the ayes have it, the ayes have it. We now come to the question that Clause 13 stand part of the bill, which is just being debated. The question is that Clause 13 stand part of the bill. As many as are of that opinion say aye. Contrary, no. The ayes have it, the ayes have it.
This is an important part of the process, because when you're doing this, you have to think of what are the pitfalls, where will the lawyers look for breaches, where will they look for ways round the legislation if they're so minded. The bill went back to the chamber a few weeks later for what we call report stage. And at report stage, amendments can be made. Following the committee stage, there are a number of issues raised. We decided that we needed to amend the legislation, amend the draft bill, so that we improved it. After report stage, we have third reading. Third reading debate is a relatively short debate, and of course, once again, I was pleased to say that the House of Commons gave it an unopposed third reading. That's almost the halfway stage of getting a private member's bill onto the statute book.
And so as the bill leaves the House, it's a very proud moment for me, having worked on this for 10 months. And I leave it in the excellent hands of my good friend Lord Best to ferry the bill safely through the other place onto the statute books and to gaining royal assent.
Question is that the bill be now read the third time. As many of that opinion say aye? Aye. Contrary, no? The ayes have it.
But once a piece of a bill has gone through the House of Commons, all its stages, so first reading, second reading, committee stage, report stage, and third reading, it goes off to the House of Lords. The House of Lords does exactly the same thing. They have second reading, they have committee stage, report stage, and third reading. Now, if a bill has amendments in the House of Lords, then those amendments have to come back to the House of Commons for consideration. This is what's known as parliamentary ping-pong, because we then, in the House of Commons, consider the Lords' amendments. If we agree with them, then they're passed. If we disagree with them, then we either vote to disagree to get it removed from the bill, or alternatively propose legislation or propose an alternative to their amendments. It then goes back to the House of Lords to see if they agree, and it can go backwards and forwards up to 3 times in parliamentary ping-pong, but when government legislation is involved. Now, when private members' bills are involved, because of the very small amount of time, relatively speaking, that's given over to private members' bills, there is no time for parliamentary ping-pong. So this is one of the reasons why it's vitally important that actually you get agreement with the House of Lords that they're not going to amend the legislation. Now, I'm very fortunate that I've worked with Lord Best on my Homelessness Reduction Act. I've worked with him on a number of other aspects of housing. He is a crossbench peer who is an expert in housing.
My Lords, I'm honoured to be piloting this bill through your Lordship's House.
So he agreed to sponsor my private member's bill on supported housing exempt accommodation regulatory oversight through the House of Lords. So he took the bill, and we had an excellent second reading debate with support from all political parties in the House of Lords. It was then given an unopposed second reading.
Second reading of the Supported Housing Regulatory Oversight Bill, Lord Best.
My Lords, the Supported Housing Regulatory Oversight Bill comes to us as a private member's bill initiated by Bob Blackman MP in the Commons. We all already owe a deep debt of gratitude to Bob Blackman for his earlier private member's bill, which I had the honour to take through its House of Lords stages, which became the Homelessness Reduction Act 2017. This has proved a seminal piece of legislation, significantly improving measures to address homelessness.
My Lords, this bill is another production from that well-known partnership of Blackman and Best, purveyors of high-quality legislation to the Houses of Parliament, following on their last production of the Homelessness Reduction Act 2017. And we look forward to further fruits of this partnership.
And then the next stage, of course, is committee stage in the Lords. Lords is slightly different in that they only have a committee stage if amendments are proposed. There were no amendments proposed, so the committee stage wasn't required.
House to be in committee on the Supported Housing Regulatory and Housing Bill, Lord Best.
I understand that no amendments have been set to this bill and that no noble lord has indicated a wish to move a manuscript amendment or to speak in committee. Unless, therefore, any noble lord objects, I beg to move that the order of commitment be discharged.
Then we had report stage. Report stage was very quick. because there were also no amendments. Finally, third reading.
Now we must thank Bob Blackman for his sterling work bringing forward this bill. Support for both his private members' bills has been provided by the charity Crisis, which does so much good work in this field. Crucially, as with the earlier bill, government backing for this legislation has been forthcoming. This essential help is much appreciated.
I would like to thank Bob Blackman MP as the bill sponsor in the other place, and the Noble Lord Best for piloting it through this House. I'm sure the whole House will hope this bill can now enable local authorities to drive up standards in their areas.
The Local Government Association, which has backed the bill.
Lord Best, Bob Blackman, and particularly to mention Crisis, who've been very heavily involved in this. I think those of us in local government will have actually seen this with our own eyes and turned up at places and actually been disgusted by what we saw, acted, tried to do things about it, but lacking the necessary clout and oomph that this bill will actually do. But be under no illusions, the hard work starts now.
The measures in this bill will drive out the rogue operators in the supported housing sector and ensure the vulnerable people who rely on supported housing services to help them live as independently as possible can be confident that they are living in good quality supported housing. I once again thank the Noble Lord Best for his sponsorship of the bill, and my honourable friend Bob Blackman in the other place for his hard work and dedication in putting this bill forward.
And the hard work now begins to put in place the regulatory framework that banishes the bad landlords and strongly encourages the good. I underline our thanks to Bob Blackman MP, who has now consolidated his position as a leading advocate for better housing for homeless and vulnerable people. I hope he soon comes high in the private members' ballot for a third time. Sincere thanks also to Crisis. As mentioned by Noble Baroness Lady Thornhill, they have, as always, provided invaluable backup, and I'd like to record my appreciation to the Bill team at the Department for Levelling Up Housing and Communities for their patience and painstaking work on the preparation and passage of this bill.
Yes, this bill do now pass. As many as are of that opinion will say content. Contrary, not content, for content's have it.
And then off the bill went for royal assent. I'm very pleased to say very shortly thereafter, before the summer break, we got royal assent and King Charles III signed off the bill and it has now become law.
My Lords, I have to notify the House, in accordance with the Royal Assent Act 1967, that His Majesty the King has signified his royal assent to the following acts and a measure: Sharps Finns Act, Cooperatives, Mutuals and Friendly Societies Act, Child Support Collection, Domestic Abuse Act, Offenders Day of Release from Detention Act, Supported Housing Regulatory Oversight Act.
So that's the if you like, the process by which a private member's bill becomes an Act of Parliament. But that's not even the end of it, because there's an enactment date on the bill. It only comes into operation as law on the operative date that is set within the bill. Now there's a good reason for this, because for example, my private member's bill in this case requires substantial amounts of regulation to be passed through secondary legislation. Now at the moment, the department is working on all of the necessary consultations that will need to take place, so that when we enact the Act, then it will, of course, be all-encompassing, including all the necessary secondary legislation. So those consultations typically take 6 to 8 weeks. Then after the responses come back, they need to be assessed, and then the secondary legislation formed. So it's often a year after the legislation is passed in the House of Commons and the House of Lords before it actually becomes law. So the sheer message that we have given over right across the board here is: rogue landlords, your time is coming to an end. Those people that provide an excellent service, thank you for what you do. Please continue to provide it, and indeed let's make sure there is supported housing across England for everyone that needs it. Well, I'd like to thank all the members of Crisis that contributed so effectively to the whole process of developing the bill and making sure we could get it through Parliament. In particular, of course, our pro bono lawyer who did a brilliant job in drafting the legislation, and I'm deeply grateful to him for what he did. The Select Committee and the clerks to the Select Committee who, of course, did a brilliant job on producing the report. I'd also like to thank councils from across the country, particularly Birmingham Council, who gave great input to the whole process and helped us establish how extensive the problem is, but also a very large number of other councils that gave us evidence of what was going on in their area to make sure that this isn't somewhere that's just something that's just confined to Birmingham. I'd like to thank my colleagues in Parliament and the ministers, all of whom were supportive of the legislation. Finally, I'd like to thank my parliamentary assistant, Hattie Shoesmith, who did a brilliant job in pulling all this together and making sure we got to where we needed to be.